Good afternoon or good morning, depending on where you are joining us from today. My name is Heidi Friedman, and I'm a partner in Thompson Hine's Environmental Practice Group. I would like to welcome you to today's webinar. This is the second in a series of webinars Thompson Hine is putting on, examining what this shift in presidential power could mean for the country and for your business. Need to get a few administrative things out of the way before we get to the good stuff. First, today's program is being recorded, and we will send a link to all attendees within 48 hours of today's presentation. Second, if you have any questions during the webinar, please feel free to use the question box located in the control panel on the right-hand side of your screen to submit questions. We will do our best to answer as many of the questions as we can at the end of the webinar, and we'll try to follow up with you if we do not get to your question. We will also be offering CLE credit for today's webinar. Please be sure to fill out and return the webinar affirmation form that can be found in the handout section of the control panel located on the right-hand side of your screen. The form provides instructions as to where to send the completed form. You will need a tracking code, which I will announce at the end of the program. In the handout panel, you can also download a copy of the PowerPoint slides and the bios of today's speakers. Thank you for your interest. If you have any questions as we go along, please use the question box. I am delighted as well to introduce my colleagues that will be presenting with me today. Joining me are Devin Berry, a partner in the Environmental Practice Group, Joel Eagle, another partner in our Environmental Practice Group, and Tasha Miracle, an associate in our group. So let me get started. I'm going to begin by talking a little bit about the new faces that you're going to see in some of the environmental priorities of our new Biden-Harris administration. First, I'll start with Michael Regan. Next slide, Joel. Michael is proposed as the new administrator for EPA. He is currently Secretary for the North Carolina Department of Environmental Quality. He is 45 years old, actually, which I had to mention because he makes the rest of us look slackers, but because of what he's done, he has quite a record in his last 20 years. And it's always exciting when the head of EPA is much younger than me now. So you can definitely see why he was a pick for the Biden-Harris administration. His background and experience aligns directly with the key Biden-Harris environmental initiatives. He spent some time at EPA as the former air quality specialist, and then he spent about 9 years at the Environmental Defense Fund, both as a former associate of Vice President of U.S. Climate and Energy, and as well as the former Southeast Director of the Environmental Defense Fund. One of the best ways to get a highlight of what we may see on a national level is by reading the North Carolina Year in Review. In fact, I spoke to somebody in one of the regions at EPA last week, and they said many EPA officials are studying this report right now. I did include a link in the slides, and some of the highlights are that under his leadership, North Carolina completed the North Carolina Climate Science Report, the first of its kind. He enforced liability for PFAS associated with the Cape Fear River cleanup. And there is a multi-billion dollar settlement for the largest coal ash excavation yet. A fun fact as well is that Michael was very involved at the Environmental Defense Fund in a program that was created for MBA students that worked in companies to be incentivized to find energy savings. It was Michael's idea to extend it to the public sector and nonprofits, and it's created $1.6 billion in energy savings to date. Another thing of note is while he was at NCDEQ last year, they denied a permit for a $468 million extension of the Mountain Valley natural gas pipeline. There was some litigation over that, but it was dropped. So you can definitely get a view for some of his priorities and accomplishments. Number 2 in charge will be Janet McCabe. Janet aligns with the Biden-Harris priority initiatives as well. She spent her career, a significant portion of her career at EPA in the Office of Air and Radiation, and in fact was on the front line crafting a variety of preeminent Clean Air Act standards, including the Mercury and Air Toxic Clean Power Plant and ozone standards. But before that, she was at the Indiana Department of Environmental Management, again in the air division. Spent some time in the Environmental Law and Policy Center and is currently teaching at Indiana University. Ms. McCabe was quoted by a prominent newspaper after the Trump rollback of the energy regulations that it was quite a kick in the stomach. And so I think we're going to see a pushback on the rollback, I'll say. A lot of the Trump's unraveling of these standards were actually the subject of litigation right now. And as I'll explain in a minute, all that litigation has been stayed. Moving on to the regional level, we actually have quite a national practice, and I personally tend to spend more time in regions 4 and 9 than I'm in 5 recently. But for whatever reason, the potential heads of Region 5 has been highly publicized, and it's very clear at the moment, at least, who the 2 top contenders are. In checking and preparing for the webinar and looking at the other regions, I did not see such clear contenders in the other regions. And in talking to a few folks at regions 4 and 9, at least there is not any identified candidates. I will say every region right now has an interim regional administrator. I have a list of those available, so feel free to reach out if anybody's interested in those. The 2 top contenders for Region 5 are Deborah Shore. Deborah is currently Commissioner of the Metropolitan Water Reclamation District of Greater Chicago. She is advocating that her focus in Region 5 would be on clean water, stormwater, and the management of the Great Lakes. There's a lot of good literature on her that says she's a little bit more pro-business, and both she and Mr. Ragland are environmental justice advocates, and you'll hear us talk a lot about environmental justice today that I'll explain a little bit more about that later. Mr. Ragland has spent time as an electric and gas utility executive, but he also spent quite a bit of time in the Obama administration as a former EPA executive. He was very, very involved in addressing the Flint water crisis. So unless you've been under a rock in the past couple of weeks, you know that climate change is a top priority for this administration. I'm not really going to go into the details of all of the climate change appointments because there are many of them. But I will let you know that Gina McCarthy, which is the head of a new department called the White House Office of Climate Policy, the first of its kind. She will also be supported by the new Department of Interior, Deb Haaland, and the Energy Secretary, Jennifer Granholm. And they and a group of very smart scientists will be moving the climate change agenda forward. There's been a slew of other appointments, and we could honestly spend the entire hour just speaking about those, but we want to get to some substance as well. I'll just mention before moving on that Brenda Mallory has actually been identified for the Council on Environmental Quality. I happen to know Brenda. She also served as the general counsel for the White House Council on Environmental Quality. She's very well known for advancing energy and natural resources agenda. So again, she fits right into some of the priorities here and will be a good, interesting add. I'm going to talk a little bit very high level about what we can expect generally from the administration. So first of all, we're going to see a reemergence of federal enforcement. The legal term is called cooperative federalism when the federal government is working with the states. And what we saw over the last 4 years is really a delegation to the states. And in talking to some EPA officials over the last couple of weeks, they were explaining to me that it's going to be, a long time before we see a total federal enforcement being the top priority, being more of a partnership is what we're going to see in the short term. And it's going to be hard to peel back some of the delegation, especially from the southern states. So I do think that you are going to see a harsher level of federal enforcement and continuing to work with the states. We're also going to expect an increase in environmental enforcement, especially in 3 specific areas: criminal, clean water, and clean air. I would also anticipate that you're going to see a return of SEPs, for supplemental environmental projects. There was policies written over the past couple of years basically eliminating SEPs in place of just getting companies to pay money when there's penalties involved in violations. And my prediction would be that the SEPs will return as an element for the administration to further their goals for, again, environmental justice. And so there's going to be more use of those, and they'll probably embracing SEPs as well. The graphs I've included here are provided by the Office of Enforcement and Compliance Assurance. I realize they're teeny tiny on your screen here, and even with my readers, they're hard to see. But what they're really intended to show you is for the past 10 years, actually, enforcement's been down a lot, funding's decreased, and staff at EPA has decreased. But in fiscal year 2021 alone, EPA funding was decreased by an additional 26%. So as you'll hear me talk about a lot of these priorities and things that the administration is looking to do, a lot of it's going to depend on funding. And I think no matter what, when we look at these graphs starting next year, we are definitely going to be seeing upticks. I actually heard just this week alone, for example, that they're trying to double the number of OSHA inspectors that will be available. Additionally, the Biden administration has issued what we'll call the freeze memo. And this is actually a normal process that each administration goes through, but they stopped any regulatory actions that are in process. And so if it hasn't gone to the Federal Register yet, it's stopped. If it's in the Federal Register, but not through the entire notice period, the folks, if the folks at EPA have been asked to withdraw it. Spoke to someone last week who was pretty unhappy about that because they're going to have to go through an approval process again. Now, some of the more controversial last-minute rulings of the Trump administration were effective, quote unquote, immediately, and so those would not be subject to the freeze. Additionally, there's a memo that's been issued that is asking DOJ to stay all litigation related to environmental regulations. And perhaps most interestingly, and what highlights probably the starkest difference from one administration to the next here, is the Biden-Harris administration has announced a 4-year look back. This is actually highly unusual. Every administration brings these changes, and there's often a 6-month look back, especially at what was pushed through at the end. But the memo on this says, quote, they're requiring immediate review of all Trump administrative actions that were harmful to public health, damaging to the environment, unsupported by the best available science, or otherwise not in the national interest. So basically their plan is to look at everything. So I think we can expect many things to revert back, and in addition to moving these new priorities forward. So I would put 4 buckets on the top of the list here when we're looking at priorities. So I've mentioned environmental justice a lot already. Environmental justice is the fair treatment and meaningful involvement of all people, regardless of race, color, national origin, or income, with respect to the development, implementation, and enforcement of environmental laws, regulations, and policies. I thought it's important to just share that exact definition so folks know what we're talking about, because that word is certainly thrown around a lot. The Biden administration is going to be establishing an environmental justice division within DOJ, again, a first, in creating a new environmental public health corps. That corps is intended to boost communities' use of data. Right now, EPA has something called EJ Screen, and that is a tool by which you're supposed to be loading data for access to the communities. But there has not been a good availability and use of technology that gets this data out to the communities, and that is definitely a goal, a short-term goal of this new environmental public health corps. Like I mentioned, climate change and clean energy are high priorities, and it's probably something that you've seen the most about in the press. And we can certainly, and we'll plan to have a separate webinar just talking about those priorities and all of the changes and requirements that are going to be associated with those. And then we have the 4th box of pollution control. And I tried to do a little bit of digging with our EPA contacts to understand exactly what was meant by this, because we have seen this a lot in some of the Biden-Harris administrative memos, et cetera. And really what we're hearing is it's a focus on emerging contaminants. Joel's going to talk to you a bunch about PFAS, and that's something that I'm sure you've heard too much about already lately. There's also going to be an increase on coal ash and plastics. But I don't think overall we're going to see much on CERCLA or RCRA. I think CERCLA has been a top priority for the Trump administration, although I'm not sure much has really changed on that front. Joel will talk about that a little bit as well. The other place where we're hearing there's going to be an increase is FIFRA, especially with COVID-19 products. And then finally, I wanted to touch really high level on what you can do now. The short version is It's been a long 9 months, and there was facility shutdowns, and people are trying to just, have the status quo keep going with regard to manufacturing and business, etc. But it's really a time to think about being proactive. First thing you might consider doing is conducting an environmental health and safety audit, ideally with an outside consultant and through an attorney. You want to consider voluntary disclosures if you find non-compliance. You want to update your environmental management system and train your employers or retrain your employees. If there is a notice of violation, oftentimes one of the requests is for your environmental management system, which helps mitigate penalties. So you do want to make sure those are up to date, distributed, and the folks are trained. You want to prepare for inspections. I already mentioned that fun fact about OSHA inspectors, but I think there's going to be a lot of EPA inspectors who have not been out for a year later this year, and they're going to be very interested in trying to complete inspections. We're also continuing to hear that EPA, various regions are moving to drones, and as I think I mentioned in the last webinar, as well as to virtual inspections. And so you want to make sure your folks are prepared, they know what they can say and don't say, and they can know what to provide and to not provide. You want to proactively improve your relationships with regulators, both at the federal and state level. And I have been very much encouraging clients to think about the communities that surround their facilities and their remediation sites. It is absolutely essential in this administration to make sure that you're looking at your community action plans and to decide and be proactive on how you can best encourage and support community involvement, because otherwise the agency will end up getting involved and impose requirements on you in this area. Finally, you want to proactively identify sustainable solutions for renewable energy and reductions of your GHG emissions. I know a lot of companies are looking to do this, and this is definitely an area where a number of very strong consulting firms are focusing some of their practices as well, and we can certainly provide information on that. So at that very high level, I will then turn this over to Joel, who's going to tell you a little bit about Superfund, PFAS, and mobile source emissions. Joel. Joel, I think you're muted. You.
Hello, everybody. Can you hear me? Heidi, do you hear me now?
We can. Technology. There you go, Joel. Sorry. Not the smoothest baton passing. You're on.
Sorry about that, everybody. So let's focus on Superfund first. As Heidi said, it's really not clear from the statistics or from our experience that that a whole lot changed during the Trump administration in Superfund sites. It was absolutely a express priority of the Trump administration to have Superfund sites move forward in the process. If they were stagnant, to list new Superfund sites and to delist Superfund sites. It seemed that a strategy was decided that let's focus on Superfund and make it seem like we're cleaning up the environment in order to perhaps at other times focus on the deregulatory program. So in my own experience, I think that that's probably true. I did see new Superfund sites come about and was happy to see some delistings, but I don't think that overall the Trump administration's focus on Superfund was too great. One aside, I had one Superfund site that was actually listed to the administrator's priority list, which was a list that was put together of a rolling list of around 10 or 15 sites that required particular EPA administrator level review. So I had one site that was added to the priority list, and then 2 years passed and literally not a single word came out of the administrator on that site. So that's the baseline that we're working with here going into the Biden administration. I don't see anything that Biden has said so far that specifically mentions Superfund, which tends to show that it's not going to be in and of itself a priority. But as Heidi said, all roads are going to lead back to environmental justice and climate change, and that includes impacts to Superfund sites. Superfund sites have very often been identified at or near areas of lower income or other reasons for environmental justice. That will be a focus for Biden administration, certainly to identify new sites that have environmental justice concerns, to list them, and for current sites as well, if environmental justice considerations are not being accounted for, to really put the pressure on PRPs at those sites to take what action is needed, whether that be increased cleanups or quicker cleanups, whatever it might take to promote the theme and goals of environmental justice. The Superfund tax was the original tax that was in the Superfund legislation that was supposed to fund the Superfund. That tax was in existence until the 1990s, and then it expired. And despite attempts over the years to reinstate it, it has never been reinstated. And I don't see that being viable. I would be very surprised if that's even proposed, but I don't see that being successful through Congress at this point. So I'm going to talk in a moment more about PFAS in general, but I would just say that with respect to Superfund sites, expect to see, once EPA designates PFOS and PFOA, two of the several thousand PFAS compounds, as circular hazardous substances, that the agency is going to put a lot of focus on Superfund sites, existing sites and new sites that have actual or potential PFAS issues. And so my takeaway here is you have to be prepared in this administration to address environmental justice concerns and be prepared for new activity at sites and new sites that have PFAS issues. So let's talk about PFAS a little bit more specifically. Biden's environmental justice plan very clearly addresses PFAS. This is a quote. The first bullet is a direct quote. Instead of making empty promises with no follow through, Biden will tackle PFAS pollution by designating PFAS as a hazardous substance, setting enforceable limits under the Safe Drinking Water Act, meaning maximum contaminant levels or MCLs, prioritizing substitutes with respect to federal procurement, and accelerating toxicity studies and research on PFAS. This is something that I tell people all the time with PFAS. It's a common mistake to just talk about PFAS. PFAS is toxic. PFAS is not toxic. PFAS will be listed as a hazardous substance or it won't. There are thousands of PFAS substances. I don't think I've read 2 articles that have the same estimate for the number of PFAS, 4,000, 5,000, 6,000 to 10,000, but there are thousands of PFAS compounds, and they have to be treated individually because they have different toxicity and they're treated differently in the environment, and they're being treated differently with regulation and legislation, both at the state and federal level. So if you remember one thing, it's remember that not all PFAS are alike. So a couple of activities that we should be looking out for in 2021 with respect to PFAS. The first, this one's really important, and that's starting on July 1st, 2021, which is the this year's annual toxic release inventory deadline. Companies now have an obligation to list about 170 or more PFAS chemicals that are used, processed in their manufacturing process. And there's, of course, a definition for exactly what triggers TRI and what thresholds. But the threshold for these PFAS is, I believe for all of them, it's 100 pounds or some other percentage threshold that will be evaluated on a case-by-case basis. But what this means is that for the first time in July, the public will have a lot more information right at their fingertips as to where PFAS is being manufactured and processed and released into the environment. This could lead to EPA and states seeking enforcement or at least scrutinizing those industries as to where the deposition or where the releases are occurring, and potentially seeking information requests or demands for reductions. And that's certainly true if and when some of these PFAS compounds like PFOA and PFOS become hazardous substances under CERCLA. As Heidi mentioned with respect to cooperative federalism, EPA has a existing PFAS action plan, and that action plan really put a lot of the burden on the states to do the heavy lifting, which the states have taken up that that obligation, and you see many states that have taken their own steps regarding hazardous substance and MCL listings. But I would see, as Heidi said, more cooperation between the feds and the states going forward. Litigation of PFAS issues, it is exponentially growing. It has grown at an amazing rate over the last few years, and I would expect that to continue. The first tier of PFAS litigation really focused on the top 3 or 4 historical or current manufacturers of PFAS chemicals, especially PFOS and PFOA, and sites around the country that have known contamination in the groundwater or soil. But I would expect, and I've started to see, that the next tier of PFAS manufacturers, but more importantly, users, those who have taken PFAS that they purchased from others and put into their own products, and there are many of them, to begin to see litigation reach their purview. Again, toxicity research is something that is in the early stages. The reason PFOS and PFOA have received so much scrutiny is because there is more established toxicity research on those 2 particular PFAS compounds. And this slide shows several additional PFAS compounds that are slated for intense toxicity reviews now. And EPA also has created another list of 20 or 30 more that will be the focus in the next couple of years. So I would advise you to know what, perform an evaluation and know what PFAS you have currently used or historically used in your processes to get ahead of the curve, rather than waiting for a litigation or enforcement to hit your books. Understand what your risks are, and we can help you with mitigation strategies to reduce those risks on the front end. So I'm going to close with a quick discussion on mobile source emissions. This ties back to Biden's priorities regarding climate change. The Trump administration took many actions that environmental groups in many states found to be against the interests of climate change, and specifically regarding mobile sources. For example, rolling back fuel economy standards from the Obama era for light-duty vehicles, and in California, which operates its own program pursuant to waivers that the US EPA must grant for a variety of different categories, such as light-duty vehicles, heavy-duty. Essentially every different category of mobile sources must have its own waiver. Trump revoked the light-duty waiver to California. Litigation ensued, and this is something that Biden is addressing, starting with executive orders that have already been issued. There are other mobile source categories, such as aircraft, that will be receiving scrutiny in order to help reduce greenhouse gas emissions. And we've heard a lot about zero emission vehicles, or ZEVs for short. The federal government will be creating policies to promote ZEV for procurement. And also I would see regulation and legislation coming down in the next couple of years to really promote zero emission vehicles. You're going to see more charging stations. You're going to see incentives for zero emission vehicles. And you're going to see other things related to reducing emissions, such as advanced biofuels and new fuel economy standards, especially for light duty and heavy duty trucks. So with that, I am going to turn it over to Devin, who is going to speak in a bit more detail on some other air initiatives.
Thanks, Joel. Can you hear me okay?
Yes, sir.
Great. You can go ahead to the next slide. Okay, well, good afternoon to everyone. I know we're going to start sounding like broken records here, but it's all about climate change under the Biden administration, and that's especially true under the Clean Air Act. So I'm going to go through real quick a little bit of history on the attempts to regulate climate change in the past, because what we're going to see, or what I suspect we'll see, is a bit of a boomerang approach where we're going back to some things that we saw several years ago. So to start with, as I think a lot of people are aware from the news, President Biden signed an executive order that the U.S. will be rejoining the Paris Climate Accord, the Paris Climate Agreement. That won't become effective until February of 2021. But I think it's important to look back at what exactly that is. And the Paris Climate Agreement was something adopted back in 2015. The U.S. was an original party to it, as were many countries all around the world. And the goal of that agreement is to limit global temperature increases to below 2 degrees Celsius to pre-industrial levels by 2050. So to put it in perspective, most of the goals set by the individual countries were to meet this goal by 2025, 2030. So the U.S. had previously committed to cutting their greenhouse gas emissions by 26 to 28% as compared to 2005 levels by 2025. Now, clearly, we're not on track to necessarily do that, given the past 4 years and our withdrawal from the agreement several years ago. But those ultimately are the goals set by the countries. The climate accord itself doesn't really put any specific requirements in place. It depends upon the countries themselves to dictate how they're going to meet those goals or how they'll contribute. The U.S. originally, at the time that they signed, we're going to do that through the Clean Power Plan, among other things, which we'll discuss. But the bottom line, I think, for the Paris Climate Agreement is it's significant from the standpoint of the U.S. being a leader on climate change, but the success or viability of the agreement really depends upon the individual countries. For example, just today I was reading an article about how China has set their goal to meet the particular benchmarks by 2060. So if countries are moving the bar on that, it may be a little bit more difficult, but it's good for domestic purposes at the moment to drive a lot of our domestic agenda. So that takes us to the Clean Power Plan from the Obama administration. And generally, I wouldn't talk about long dead rules, but this is one that will come back. So I think it's important, or some form of it will likely come back. So it's important to understand what it was. And what the Clean Power Plan did was it required a reduction of greenhouse gas emissions from electric power generation. It was limited to utilities by 32% by 2030 relative to 2005 levels. And the way that it was doing that was ultimately requiring what were called best system of emission reductions, or BSERs. And there was a variety of ways that states could meet the objectives being set by the feds. They could reduce greenhouse emissions by improving the heat rating of existing coal plants, or they could substitute, for instance, coal power with natural gas power, or they could substitute to a renewable energy source. There was also some other options in there as it relates to state plans, things like reducing overall electrical usage on a residential level. So that was the general framework of what the Clean Power Plan was. And I think most of us here are aware that it was, of course, challenged by 27 states. And what's important is that it was challenged on the basis that those control technologies I just mentioned, some of them went beyond regulating the source itself, putting a control on a particular piece of equipment. Because of that, these states were challenging that. The Supreme Court ultimately stayed the rule even before the appeals courts could rule on the validity of the jurisdictional questions of authority under the Clean Air Act. And then, of course, we know the rest. The Trump administration came in at that point and then repealed ultimately the Clean Power Plan. So because the Clean Power Plan ultimately was something that was being passed to regulate greenhouse gas emissions, which is something that past decisions in the United States have said the Clean Air Act is there for, EPA couldn't just, under the Trump administration, couldn't just repeal the Clean Power Plan. They had to replace it. So they did with the Affordable Energy Rule, or I guess it's the Affordable Clean Energy Rule. And this rule was passed in 2019, and it reduced greenhouse gas emissions, or it set a goal of between 1 and 1.5% by 2030. So you can see from a comparison standpoint there, you're talking about 1 to 1.5% compared to 32% under the Clean Power Plan. And the Affordable Clean Energy Rule largely focused on saying, well, industry is going to actually force additional reductions in greenhouse emissions driven by market forces. Companies are generally moving away from fossil fuels in general. And there was some debate about that. But the most important part about or one of the important parts about the Affordable Clean Energy Rule was I talked about the BSERs, and there was a variety of options available under the Clean Power Plan. Under the Affordable Clean Energy Rule, it was only one. You could only look at the heat rate improvements for a source. So you had to make more energy with the same fuel. And you could also consider things like cost when you're implementing those controls. So that goes into another issue, and I want to just accent it, is that during the Trump administration, EPA just recently in December of 2020 changed some of the rules on how essentially EPA does their cost accounting when looking at whether or not a control is appropriate based upon a cost perspective. And they limited the scope of what you could look at from a cost perspective, really just to dollars and cents. So when we talk about the Biden administration unraveling rules from the Trump administration, it gets extremely complex because we're here talking about the Affordable Clean Energy Rule. But a lot of these things that are required in this rule are ultimately going to go back to this cost evaluation, which implicates yet another rule. So it's certainly going to be complex and a bit confusing. But the good thing, at least from Biden's administration's perspective, is in January of 2021, so just I believe it was last week, the DC Circuit decided the case. When the Affordable Clean Energy Rule was passed, it was of course challenged by many environmental groups and health groups. And the DC Circuit vacated and remanded the rule, saying that EPA under Trump misinterpreted the Clean Air Act, going back to that same issue of can you regulate beyond just the source itself under the Clean Air Act? And they said, Trump EPA, you're incorrect in your interpretation that you can only regulate the source. You can regulate beyond the source itself. So now the rule is essentially gone. It's gone back now to a different administration's EPA, and I don't expect we'll see the Affordable Clean Energy Rule will see the light of day again. So now we're, next slide, please. So now we're in a situation, well, what are we going to see under the Biden administration itself on climate change? Well, as I alluded to before, it's very likely we're going to see a return to the Obama era approach, something like the Clean Power Plan. If not, I think you'll see evidence of that not only from the agenda here, but also some of the players that Heidi talked about previously are a lot of the same players that were in EPA back during the Obama administration. So I think it's very likely we'll see that. At a high level, and I think you'll be disappointed somewhat at the end of this, in that I can speak about what Biden's climate plan is, but the details of the plan are largely ambiguous at this point. And he set a target of 2050 for net zero emissions with an earlier target of 2025 for some initial milestones to be met. And he hopes to go through that, and you would presume that it would be something along the lines of similar legislation or rules similar to the Clean Power Plan, but time will tell. Another thing relevant, I think, for this particular audience is that there will be some additional greenhouse gas reporting for public companies and supply chains to public companies. And whereas I think a lot of our publicly traded clients are already reporting in their SEC reports something related to climate change, there's not a whole lot of uniformity with that. So I think we might end up seeing perhaps some additional reporting requirements coming out of the Biden EPA administration, whether that be in the form of EPA rules or perhaps rules coming out of the SEC instead. I think that there's a possibility there that it could change even the metrics of how that's being measured if it's a particular way in which you have to quantify it. Again, this is something that a lot of you are already dealing with within your companies, but it might just be altered slightly in the future. Other aspects of this plan are incentivizing low carbon manufacturing. Frankly, I'd like to see a lot more details on this beyond what's been provided so far, which is largely tax incentives and subsidies. And there's a lot of reading between the lines of his plan, talking about a lot of federal money being available both to private and public industries that are really willing to research new technologies to meet this particular objective. The next one here is federal permitting will require greenhouse gas impact accounting. And I bring this up primarily because it goes back to the same issue of how you account for costs associated with greenhouse gases. I think that permitting structure is going to be a little bit more complex, quite a bit more complex in the future as that accounting is changed from the Trump administration to the Biden administration. And then last thing I'll mention with this is these are obviously ambitious goals that we're looking at here and that Biden has, and I coin them right now as political more than anything else. I think he's got a greater chance of passing legislation than he did initially. But that being said, when you have plans this ambitious, I think you even with the liberal side of Congress, you're going to get some folks that are more towards the middle that may not necessarily support as comprehensive of a reform as you're seeing, but we will see. I think the biggest obstacle would be obviously the Supreme Court is substantially more conservative at this point than it was in the past. When you're talking about things like the Clean Power Plan, we've gotten some indication from the appeals court that the strategy or the general approach wasn't necessarily incorrect. So there's a question of whether it would even get to the Supreme Court, but it is a hurdle nonetheless. Next slide, please. So then beyond the climate change, I think the other thing you have to look at is the other potential rollbacks, which I expect there will be quite a few from what the Trump administration has done. And I've identified some general categories here, but first I wanted to mention, just I believe it was on January 20th, President Biden issued an executive order to review recently issued rules. And there were some very important rules on that list that they plan on reviewing. One is the Ozone National Ambient Air Quality Standards and the PM 2.5 National Ambient Air Quality Standards. Now, those standards form the basis for the Clean Air Act regulation of criteria pollutant, and they determine whether or not a state or areas of the state are in attainment or non-attainment for new source review, which is obviously a very expensive proposition if you end up in a non-attainment area. There was a lot of pushback when Trump EPA ultimately determined in December of 2020 for both contaminants that the current levels remain safe. Those evaluations will be reevaluated, and some folks believe that the reevaluation of the PM 2.5 NAAQS may actually be an indirect way to actually regulate electric utilities more, in that they're normally a pretty large contributor of that particular pollutant. And they could address climate change essentially through regulating PM 2.5 instead. So I think you definitely will see EPA reevaluating those two determinations. The other aspect here is the new source review policies that have changed under the Trump administration. And frankly, I think some of these were needed clarifications, although they are deviations from EPA's historical approach. And I don't have time to necessarily go over each one of them, but they addressed issues like project aggregation, project emission accounting, how you determine a common source or an adjacent source for new source review permitting, as well as some enforcement policies relating to how actual emissions play into an enforcement determination when someone has done a projected actual evaluation under the new source review. So I guess my guiding light on that would be some of these have been issued as a final rule, and those are less likely to be, or there would be a greater challenge for the Biden administration to repeal. But things such as the adjacency and common control and these enforcement discretion policies, I think they're very likely targets for the Biden administration to reverse course on. So I would encourage everyone to keep an eye on the Biden administration's attempt to potentially claw back some of those new source review changes. And I'm going to skip over the once in, always in rule. That related to facilities reclassifying as non-major sources for hazardous air pollutants. It was issued as a final rule on October 1st, 2020, and I do expect it will likely stay in place under the Biden administration. The last thing I want to mention is the last box here, which is the interstate transport rule. And this relates to regulating upwind states essentially and their impact to affect downwind states' ability to comply with their national ambient air quality standards. So right now, under a judicial decision, EPA has to issue this cross-state air pollution rule, which is centered around making those upwind states to reduce ultimately ozone to allow the downwind states to be able to comply with the 2008 ozone National Ambient Air Quality Standards. The rule has to be issued by March 15th, 2021. It isn't proposed right now. The reason I bring this up is because right now it's focused on utilities and reducing their NOx emissions to be able to meet those requirements. But there is at least some question on whether or not the Biden administration will potentially open that up beyond electric utilities, even into the manufacturing sector, if it turns out that the ozone max for the downwind states is difficult to obtain, or a court determines that this rule isn't sufficient like they did with the prior version of the cross-state air pollution rule. I think the Biden administration has a little less leeway on this one to get too involved, because there is this judicial mandate for the issuance of the final rule. But it is something to keep in mind, especially as we're talking about reevaluation of ozone max, because this will, become a complex issue that might resurface even after the final rule is issued in March. So with that, sorry for rushing through it so much. There's a lot to talk about, but I will turn it over to Tasha Miracle, who's going to be talking about water implications.
Thanks, Devin. Can you hear me?
Yes, I can.
Great. Thank you. I appreciate it. Good afternoon, everyone. As Devin said, I'm going to be talking to you a little bit about some of the water priorities we can expect to see out of the Biden administration. These issues aren't quite as lengthy and perhaps will not be focused on as much by the Biden administration as sort of the climate change and environmental justice issues that Devin and Joel and Heidi have touched on, but there still are some big ticket items that are important to go over. Before I jump into those, though, I do want to note that I have some soothing water photos on this slide and the next, and I have been told that I have a voice for radio, not to be confused with a face for radio, which would be very offensive, but a voice for radio. So please just sit back and enjoy my water graphics and listen to my voice and let them soothe you into a meditative state as I talk to you about some of these water priorities. The first is the Navigable Waters Protection Rule, and unfortunately this has been a big ticket item for 20 plus years, honestly, since the inception of the Clean Water Act, but particularly in the last two administrations. And President Trump's EPA administration did issue the Navigable Waters Protection Rule, which many viewed as sort of a rollback on the types of waters or waters of the U.S. that are protected by the federal government. That did become effective in June 2020, and everyone pretty much uniformly recognizes that this is a high priority and likely to be replaced by the Biden administration. Of course, as I'm sure you recall, the Obama administration issued its own clean water rule, which was sort of more focused on those waters that have a significant nexus to traditional navigable water. So many saw that as sort of an expansive view of the Clean Water Act's regulation, where Trump's rollback was focusing on, not surprisingly by the title, navigable waters, which is the language in the Clean Water Act, and sort of drew back the protections for intermittent streams, ephemeral streams, and isolated wetlands. And many states have challenged that rule, just like they did President Obama's rule. Although unlike President Obama's rule, this one did not result in a nationwide stay. It was only stayed in Colorado. But yeah, you see most of those challenges in the western states because of sort of the types of waters that were perhaps taken off of federal jurisdiction based on the language of that rule. And as Heidi mentioned earlier, there was a memo that came out asking DOJ to stay litigation related to these rules. So this is certainly one that likely EPA will not stand behind, and industry is going to have to come to the defense of it more strongly if they want to try to advocate this rule. But I look to the Biden administration to sort of, issue a new rule similar to what President Obama's rule was like. And there are some who perhaps are being overly optimistic in saying that maybe because of President Biden's focus on climate change and environmental justice, he'll use some of these water priorities as an opportunity to be more moderate and try to pass something that is less likely to be challenged. Whether that's overly optimistic or not, I think only time will tell, but it truly will be time telling, because keep in mind that it took President Obama 6 years to issue his clean water rule, and then it took President Trump 3 years to issue his rule. So this one certainly will not happen quickly. The next rule that we all expect will be a big ticket item for the Biden administration is the Clean Water Act Section 401 water quality certifications rule. And that one was just finalized in 2020 as well. And I'm sure many of you are familiar with Section 401 water quality certifications coming from the state. Those have to be issued for any projects that require Section 402 or Section 404 permits. The state has to issue its water quality certification before the project can move forward. And under the typical understanding of the rule, the state has a reasonable time period or 1 year. But it doesn't always follow that timeline, and states often try to get a little bit creative about how they can extend that timeline, and it has resulted in delaying several big development projects and just projects generally. And so the Trump administration sought out to clarify that rule and set some more strict requirements around the timing to keep states from sort of delaying these water quality certifications and unnecessarily delaying projects. So they did, put some language in the new rule, sort of trying to roll back on that timing, and not really roll back, I guess, more specify a time frame that is a little bit more clear than what states had implemented under the previous rule. And they also sort of tried to roll back the scope a little bit of the rule, and so states only could focus on discharges in their 401 water quality certifications. So there is litigation over this rule as well, and again, it is likely stayed, but it again is probably a high priority for the Biden administration to make some changes here and perhaps come up with a rule, which will take time to devise, but that will sort of shift and perhaps expand what is expected from states under the water quality certifications rule. Next slide, please. So the next two items are similarly big ticket items, but perhaps will move a little bit more quickly than the last two. And the first one is the US EPA's guidance helping EPA and other agencies interpret the Supreme Court's Maui decision, which found in 2020, as I'm sure you're all familiar, that certain discharges to groundwater that are considered the functional equivalent of a direct discharge can be regulated by the Clean Water Act. So at the end of 2020, the Trump administration issued this guidance to sort of help agencies interpret that Supreme Court decision. There were 7 factors in the Supreme Court decision, including time of travel and things like that, that would help people assess whether the discharge may be considered a functional equivalent, but it wasn't exactly clear. Many joke it was a muddy decision. And so US EPA put out this guidance. Of course, guidance does not take the work that a formal rule would take to rescind. So this one likely will be on the chopping block quite quickly, and you'll see perhaps the Biden administration come out with some guidance that is a little bit more inclusive of those when those groundwater discharges are the functional equivalent of a direct discharge. And then the next one relates to some nationwide permits that the Army Corps of Engineers issued this year, and they issued several of those ahead of their anticipated expiration date in 2022, which was a surprise to many. But that rule, although it was issued this year, it will not be final until March 15th. So Heidi mentioned the freeze memo. This rule likely will be drawn back. And again, that will not be a huge shift for anybody who is subject to these nationwide permits in their projects, because it will just mean that the prior nationwide permits will remain in effect until 2022. Likely that is what it will mean. And then when they expire in 2022, the Biden administration will come out with its own revised nationwide permits. Next slide, please. And so I have a few new priorities I want to talk about as well. And these aren't actually new priorities, of course, but they are sort of a new high priority for the Biden administration in a way that they were not high priorities for the Trump administration. And the first deals with plastic waste regulation. And this is both on sort of the plastic manufacturers, the plastic pellet side, as well as companies who use plastic in their products, which I think is quite interesting. I'm sure that many of you have seen sort of in the news some of the plastic waste litigation in California and Texas related to those little plastic pellets from plastic manufacturers, and could have anticipated that this would be a discharge problem under the Biden administration. But I think it is interesting that we are expecting to see that there will be an increased focus on just, like you're seeing here in this picture, although not as soothing as my last two pictures, but you're seeing the plastic water bottles, again, sort of companies that use plastics for their consumer products, and talking about end of life of plastics and how that is impacting water quality and perhaps increase regulation there. So that is a unique focus that you wouldn't have expected to see under the Trump administration. And then the next two relate to enforcement, and Heidi sort of touched on these, but we're all expecting to see increased Section 404 wetlands enforcement actions. That is a typical high priority enforcement area for the Clean Water Act, and it was down significantly under the Trump administration. So all experts pretty much agree that one's going to increase. And the same with criminal enforcement of the Clean Water Act. That is typically the most common environmental area you'll see criminal enforcement. And so everybody is again anticipating that despite the rather, the lull under the Trump administration, that will increase under the Biden administration. And then the next two are a little bit broader and not as specific, but I'm sure you've all seen news sort of related to these issues as well, is that the Biden administration is going to focus on protecting American lands and waters, both by, issuing more conservation measures and just by limiting the oil and gas activities that can occur on public waters. Next slide. So the last thing I want to talk about, and I'll go quickly here, just a couple things, are the Biden administration's likely drinking water priorities. And perhaps you will see the Biden administration be more aggressive, even more aggressive here than you will on the Clean Water Act side, given some of the issues related to the PFAS substances Joel mentioned, and of course the Flint lead crisis. Everyone recognizes that there likely is going to be a more aggressive regulatory approach to contaminants in drinking water, particularly like the PFAS substances and lead, which is important to consider from the drinking water side. But as many of you know, MCLs issued under the Safe Drinking Water Act are often drivers for cleanup levels at Superfund and RCRA sites. So it is important to keep in mind and pay attention to those issues from that angle as well. And you see this holding polluters accountable language here to protect drinking water supplies. That is language from Biden's campaign promises. So definitely a priority for him to focus on that issue. And then last, everybody expects to see an increased focus on drinking water and wastewater infrastructure. So that will impact, both the pipelines and plants for drinking water and wastewater infrastructure on the private and the public side. So just another thing to focus on in terms of priority. And perhaps if you manufacture pipes for wastewater and drinking water infrastructure, you'll see a boom in business related to some of those replacements. So that is everything for me. I know we only have a few minutes left for questions, but I don't know if I want to hand it back to Heidi to address those or to
Yep.
leave that up.
Tasha. Yep. Thank you so much. We do have just a few minutes for questions. And so feel free to again type in your questions in the questions box. I have one or two here we're going to try to get to, but the moment you all have been waiting for, if you are seeking CLE for today's program, the tracking code is ENVIROCLE, ENVIROCLE. Again, the tracking code is ENVIROCLE. And if you have additional questions after today's webinar, you can reach out to any of us or your current Thompson Hine lawyer, and we will be happy to answer them. The first question I have here is, has there been any commentary by the Biden administration that you are aware of that would speak to the increased regulation and impact on returning manufacturing to the U.S.? Sounds like the approach may have the adverse effect on expanding manufacturing to the U.S. Great question. I was thinking a little bit, I'll start and just say that I was thinking a little bit about this morning. Some of you may have seen that he signed an executive order, President Biden signed an executive order yesterday, closing some loopholes in the Buy American provisions, as they're called. And the goal there is that it would require at least the government to buy a certain amount of its product, or a significant amount actually, of its products in America. So one would argue that it would increase manufacturing, etc. But those of us on the environmental sides of things certainly realize if you're going to expand your manufacturing plants, we like to call it change management on our team, which triggers lots of permit and other requirements. And if permit requirements are going to trigger climate change analysis and lots of these other things, it certainly is going to be a long and involved process. And so I have not seen anything that dovetails between what is clearly a commitment to help manufacturing return to US, as well as how that's going to dovetail with the facilities and how they're going to be able to comply with this. So I think that is a time will tell, and we are going to be following this very closely. In fact, if you're not currently receiving our updates and invitations, you can go to our website and register to receive our mailings on the publication tab. But our group also has the Environmental Laws podcast, which I know is a form many of us really like to use these days. And the podcast explores current topics in environmental health and safety laws in the United States from the perspectives of Thompson Hine attorneys, the regulated communities, regulators, and sometimes special guests. And we are going to definitely have a podcast in the next couple months as things develop. As you know, it's really changing daily, and we're going to keep our finger on the pulse here and make sure we monitor things and can advise on some of these very good questions as well. Our next webinar here is in the transition of presidential change will be on Tuesday, February 2nd at 2 p.m. The webinar will address employee benefits under the Biden administration. And once again, the CLE code for today is EnviroCLE. So we're just about a minute over, and if we have any other questions, we'll definitely try to get back to you directly. And otherwise, we thank you very much for joining us, and we wish you a good rest of the day and stay well. Take care.